Lights, Camera and Action. A brand new show every Wednesday at 7 p.m. only on Awaz Entertainment. Hello everyone, good evening. I am Kubra Ali. You're watching Lights, Camera, Action on Awaz Entertainment. We have tonight a wonderful lawyer with us as my guest. So let me welcome Sanober Naz. Hi Sanober, how are you doing?
I'm good, thank you so much, Kubra.
Can you please introduce yourself?
Yes, sure. First of all, Kubra, I would like to thank you so much. You gave me an opportunity to speak very important legal issues.
My pleasure.
And let me introduce myself. My name is Sanober Naz. I'm barrister and solicitor. I have been running my law firm in Ajax for past 10 years.
Nice.
And my areas, my actually legal practice cover more range of areas, including criminal law, family law, civil litigation, estate litigation, real estate, and immigration.
That's amazing.
And also, Kubra, we have the privilege for assisting many clients in achieving their successful outcomes in their cases.
Wow, amazing. That's so nice. Can you please let me know why did you choose this profession as a lawyer?
Okay, this is a good question. Basically, Kubra, I was very young when just I had a dream I want to be a lawyer because I really want to participate, to work for the community.
That's so nice.
And that's why that was my dream, to be a lawyer, to work for the community and members and publics. And also I choose to do on specific fields, basically first of all, because I'm general litigation lawyer, my practice is not limited to one areas. And I would say why I choose to be a criminal lawyer, the reason because I just want to be a criminal lawyer. I want to be used in practice of justice and the human rights, and and I really want to protect the basically individuals, and mostly I would say, because the criminal law is not only for the courtrooms and the statutes, because criminal law is when you protect the fundamental rights of the individuals, and also we do and protect them, and we basically ensure the legal system functions properly and responsibly.
Oh, nice, nice. In your practice, what types of criminal cases do you handle most often?
Kubra, I just deal all type of criminal offenses, and usually we deal in our law firm is domestic violence, assault cases, all type of assault cases involving aggravated assault, sexual assault, assault with weapon, and we also deal fraud cases, robbery cases, theft over 5,000, theft under 5,000. My law firm is also deals some indictable offenses that comes under 553 section of criminal code, that is called least indictable offenses. We also deal some summary conviction offenses, and we also deal some serious indictable offenses that including even attempted murders, manslaughter, these type of offenses our law firm is basically handling.
Wow. That's a lot. When you take a criminal case, how do you usually prepare strong defense for a client?
Yes, this is a good question, Kubra. Basically, there are possible defenses we can use in the criminal law proceeding. And there are, I would say, the major defenses, including basically the innocence alibi defense, the lack of intent, self-defense, mental disorder, necessity, and duress. There are other defenses as well, but these are the major defenses. And also, sometime when the criminal charges have been laid out against someone else, there should be it can be possible wrong allegations made out against them. And basically, police officers rely on the statement of the victim and of the complainant. Whenever they receive any complaint, they relied on their statements. And in this situation, how we handle, basically, we try our best to provide strong evidence that shows basically their allegations are not reliable allegations, and these are not realistic, and these are based on the wrong and false information. In under basically what we can provide, we can argue on the contradictory statement of the witnesses during the trial or even before the trial. We can argue to the court for the there is a lack of video and audio recordings. Basically, there is very strong evidence that the Crown prosecution used the video and audio recording because there is a strong evidence. Because Crown prosecutions basically have the burdens to prove all the elements of offense beyond the reasonable doubts. And we always, the criminal defense lawyer, always argue if we find there is a lack of these evidence, that is called the primary evidence, and direct evidence, there is a lack of direct evidence, and we can argue, if there is any alibi evidence we can provide. On that basis, we always try to get the charges withdrawn. And we had the success basically in the past, all the criminal cases we dealt, even the client charged for 9 or 10 criminal charges. But the problem, the Crown Counsel's prosecution failed to provide all the direct evidence on each elements of offense. And basically, many of the charges were not based on the right allegations, but basically the officers relied on the statement, because always this burden goes to the Crown Counsels to prove in the court. And if Crown Counsel's prosecution failed to provide, and defense counsel always try. I do not urge my clients to enter into a guilty plea until and unless I find the client actually have committed a criminal offense. And this is also voluntary choice of the client. We always inform to the client, even if you committed, but this is a voluntary choice. We always inform to the client what is the legal consequences when you enter into a guilty plea, and when we provide the complete advice, the legal consequences as per the criminal code requirement, the legislation requirement. And if client voluntarily choose, they can do, but usually we do not urge the client if client do not involve in the criminal offense. And we always try, if client involvement is not, then the best option to get the exit, either by way of the peace bonds or either to drop the charges by way of any counseling programs.
Wow, okay. So now let's shift to the family law. Many of our viewers face questions during separations, right?
Yes,
and
exactly.
What are the basic legal rights someone has when separating in Ontario?
Kubra, basically the family law, there are very, very big scope. I would say there's a lot of issues involved in the family law proceeding. Because when the community usually talk about the family lawyers, they always have impression in their mind, this is basically, this is a divorce lawyer, they will do divorce. But this is not fact. Basically, family law is not only involving a divorce, because family law proceedings, a lot of issues involving, including, because if you have a minor children and you have separated, there are a lot of issues. You can definitely, the child sports matter will be involved, and
maybe counseling.
Exactly. And children decision-making responsibility will be involved, and both parents will dispute who will get the child decision-making responsibility. Either they will take the sole decision-making responsibility or they will take the joint decision-making responsibility, because this disputes is usually be determined by the courts, and court always make a decision what will be the best interest of the child. And also there is certain other issues also involved, and the spousal support is involved. And if the spouse is entitled, there is certain grounds when the spouse can claim for the spousal support. and there is certain other issues involved, suppose the property claims.
Right.
If both parties,
that's important.
Yes, exactly. Of course, if both parties own any property, doesn't matter if both spouses own, even one spouse own any property, it involving the issues of the property. And this is not a simple issue, because always there is a lot of financial disclosures will be exchanged between the parties, because until and unless both parties exchange with the financial disclosure with each other, the court will not be in that position to determine, because there is a lot of other issues. If there is a domestic violence involved between
then that's
the parties,
other story, and it actually it's the criminal.
Domestic violence, of course, if there is the violence involved, the physical
does
violence.
It actually comes under the criminal law?
If it is involving the physical assault, then it becomes a criminal.
Absolutely.
If this is psychological, unfortunate, no criminal charges. Until and unless there is a physical violence is involved, it becomes a criminal matter. It comes also, the charges can be laid out, of course. And if there is a domestic violence involved in the family law proceedings, the one spouse can apply for the exclusive possession of the matrimonial home on based of if there is a history of violence. Always this is up to the court. The court have discretion power to decide if the victim is entitled for the exclusive possession of the property or not, because there are these type of issues involved. And also I would say this is very important information, because any client when contact us for any divorce proceeding, and we always encourage the client to get counseling first before taking any divorce case to the court.
Sorry to interrupt, counseling with the partner or just separate counseling?
The counseling is the counselor who can provide. This is not from the partners. This is from, there are certain counseling agencies who provide the counseling to both of the partners. It can be at the same time, it can be separately, but it really helpful to assist them, to encourage them. If possibility of reconciliation, they can reconcile instead of they move for the divorce. And also, Kubra, there is obligation under legislation. The Law Divorce Act basically indicate the both lawyers and the court have obligation to ensure if there is no chance of reconciliation, then court usually grant the divorce. And lawyers will not take the case to the court until and unless they encourage the parties for counseling. But if they find there is no chance of success, because parties tried their best and multiple times they tried to get counseling, but they failed. And if there is no chances of success, then unfortunately there is no way other than to file a divorce proceeding. But it do not start with divorce and ends with divorce. Unfortunate, if the children are involved, property involved, it's taken few weeks and years to get resolution.
So this is during the separation time.
Yes.
Whatever. Nice.
Yes.
So do couples need to be legally separated before they can apply for a divorce?
Basically, there are 3 grounds when you can apply for the divorce. Basically, number 1 is when you have separated at least from 12 months from the partner. This is one of the ground. And because why the law give the 12 months period? Because it can be possible if both parties reconcile and they try to resolve their issues. After the 12 months separation, they find, oh no, this is not easy to separate from the partners, and they try to reconcile.
So they give time for 12 months.
Exactly. And the second ground is cruelty. And if one partner behavior is cruel towards the other partner, there is no need to wait for 12 months. And they can file divorce immediately. This is the second
How will
ground.
they prove?
They can do, because there is certain reasons they can provide evidence. It can be psychological, it can be physical, but this they can provide.
They have right.
If they have, of course, if they have shared this information with any social, I would say the social worker, the doctors, the police, or there is any because they can provide evidence in their pleadings. And also this is the second ground, because they do not need to wait for 12 months. And the third is basically adultery. Adultery means if your spouse committed adultery and there is no need to wait for 12 months for the separation, and the other party, it's mean the person, other spouse can apply immediately for the divorce. Okay. But these are three grounds when you can apply for divorce proceeding. But right. in the divorce proceeding, you are, because the same thing, if you have the children, you have another issues, property matters, then in your divorce proceeding court application, you will include all the reliefs. But if you are not filing simple only divorce, then it usually take few weeks to months or sometimes few years.
Wow,
because yes, exactly. Until all others matter will be resolved, and especially if the children's issues are involved and both parties fail to make good arrangement for the children. Suppose they did not arrange for the child's support matters, they did not arrange for the children's decision making, who will get the decision making, who will how the parents will use the parenting time. In this situation, basically, the court will not grant the divorce until and unless court find there is good arrangement have been made for the children. Because that's why the parties always find if they will start from the divorce application, it will be ended immediately. No, the answer is no, because until all of this matter will be resolved, the divorce will not be granted.
So the divorce for the, who doesn't have children, that's for them, it's easier.
Right. Yes, but if there is a property matters involved,
then
I would say
something.
Exactly, it's take
it's
a
the
time.
Same.
Yes, exactly. It will take.
How long it usually takes, maximum or minimum? Like
the time period is depend on how many issues are.
Okay.
But basically, I would also discuss, because the family court process is very flexible process. Because when any party start with the family court proceeding in the court by way of the court application, usually the court allow 3 separate conferences. And these 3 conferences is called, the first is case conference, second is a settlement conference, third is a trial management conference. All these 3 conferences will be held in the court before the judge. The mainly purpose of these 3 conferences, the judges encourage the parties to resolve some of your issues during these conferences. Because they usually court allow the time parties to make any settlement. If the parties enter into a settlement, the parties' lawyer usually prepare a minute of settlement, and court will endorse the minute of settlement. It can become a temporary or final order of the court. If parties cannot resolve 100% their issues, they can resolve maybe 50%, 40%, 30%, but at least some of the issues they usually be successful in resolving in any of these conferences. If suppose parties fail to resolve 100% issues in any of these conferences, then matter goes to the trial. And trial is, I would say, in my family cases, 90% cases we usually get resolution before the trial. And the reason that trial is too costly, and courts, law and lawyers always encourage the parties to get resolution, to enter into a minute of settlement before taking this matter proceeds to trial. The reason is because the trial, mostly the people, they cannot afford, because it can cost be 80,000 to 100,000, or it can be more than that. It can be more than that. And the family court, if there are more issues involved, they usually take 5 to 8 days trial. And standard fees, the lawyer charge 80,000 to 100,000.
That's a lot of money.
That's why there is a lot of money involved in this situation. Always the lawyers encourage the parties to enter into a settlement before the trial. Yes, exactly.
Let's continue this after a short break. So we'll take a short break and we'll continue this interesting subject. Thank you very much.
Thank you.
In times of trouble, what do? Do you face it alone? Or do you find the best help that you can? At the Law Office of Snober Naz, we fight for your rights, no matter what the allegations. We will protect your rights and defend your case in any type of criminal charges, guiding families through some of their darkest times in any type of family law court proceedings. We're a general litigation practice law firm with extensive experience in criminal law, family law, civil litigation, real estate, and immigration, serving you from our 2 convenient locations, Ajax and Mississauga. Call 905-683-7449 or visit snoberlawyer.ca.
Legal problems don't wait, and neither should you. I'm Rohit Sharma. Whether you are facing criminal charges, buying your first home, or protecting your family, I'm here to help you. When your future is on the line, experience matters. At Rohit Sharma Law, we deliver results with clarity and care.
At Rohit Sharma Law, we specialize in a wide range of legal services, including family law, criminal defense, real estate transactions, immigration matters, civil litigation, and notary public services.
Book a consultation today. Let's take the next step together. You can call us at 416-741-1115 or email us at info@rohitlaw.ca.
Experience the authentic flavors of South India at Saravana Pavan. From our kitchen to your table, savor a taste of tradition. Fresh, flavorful, and 100% vegetarian. Join us at Saravana Pavan, where every meal is a celebration.
Hello, welcome back. I'm Kubra to my show Lights Camera Action on Awaz Entertainment, and we have a wonderful lawyer, Sanober Naz, sitting with us. Hi, Sanober. Thank you so much for the great information about the family law. So I have a few more questions for you.
Sure.
Can you tell me how is property typically divided under Ontario's family law system?
Yes, this is very, I would say, is a big issue and matter in the family law proceedings, because property dispute is not easy, basically, issue. Because property, first of all, I definitely will discuss which property matters will be discussed and determined in the family law proceedings. This is basically the property statutory rights is available to the married couples under the Family Law Act, and this property rights including matrimonial home and the equalization payment. Okay. And the matrimonial home means the home that you own, even one spouse own the home. Okay. And doesn't matter if the other spouse do not own the home, but when both parties living at the same house,
that's a matrimonial.
After the marriage, it become matrimonial home.
Right.
And both parties have statutory rights for the possession in the matrimonial home. And second is equalization payment. Equalization payment is also, this is a property right. Equalization payment is basically both parties after separation in the divorce proceeding will share and exchange with other party a lot of financial disclosure, including all the assets value they owned on their name and all the debts, liabilities, the expense, income, whatever they own their assets by them, right? But after basically determining who actually have the high net family property will be liable to pay the equalization payment for difference to the other party, because there is until and unless both parties exchange full and financial disclosure, the parties will not be in that position to determine the net family property. And when the both parties determine, we take in the court, because if this is matter in the court, then court will rely on the net family property statement if usually the lawyers are involved and both lawyers prepare the net family property statement. Sometimes there are many clients, Kubra, there are many clients who do not involve the lawyers. And in the family court proceeding, the reason maybe they cannot afford the legal fees, because lawyers usually charge on very highly rate in the family court proceedings. And what happened, because they do not aware about the consequences, because they do not prepare the documentations, the net family property exchange, financial disclosure in that way. That's basically they're required to do. And what happened after that, court basically rely on their statement. If court make any final order, it will be a big problem, because they don't know that is not easy task to change the final order of the court. And this is not easy. This is very hard when you apply for the variation application. This is very big steps they need to take. Yes.
So before we wrap up, what final message would you like to share with the audience, especially for those who might be dealing with legal challenges right now?
Yes, definitely. I would say, Kubra, the legal awareness is one of point for the legal protection. And my advice for everyone, for every client, to listen, learn, and ask questions. If this is the client's personal matter, they must, this is a highly recommendation, they must consult with qualified lawyers, and they do not rely on their self-representation, because they do not aware what will be the consequences if they get any final orders from the court. That is really hard to change, and to file an appeal and to get the variation, because always the lawyers, the qualified lawyers who have experience in the fields, they can give proper legal advice to the client and to protect their rights, and to give proper pathway how they can achieve and how they can get success in their claim or in their cases.
Thank you so much. It was really nice. We got so much information in regards, and thank you everyone for watching. If you have any questions, anything, you can always get back to Sanober Naz for your questions, be it criminal law, be it family law. Any questions, you can always get back to her. Thank you very much for coming on my show.
Oh, you are welcome.
Thank you. Okay, so let's wrap up. I'll see you next time on my show, Lights, Camera, Action on Awaz Entertainment. Good night.